All right, welcome back. Our next panel is called Ransomware 2.0, Responding to Exfiltration and Name and Shame. So this is a very interesting topic that's kind of a new topic for this conference. Let me start off by introducing our moderator, Travis LeBlanc. Really, this whole panel has great, interesting bios. I'm going to try to do it justice, but also keep it short. So Travis is a partner at Cooley and vice chair of the firm's cyber and data privacy practice. But a lot of other things. In recent years, he's been selected by the Department of Commerce and the EC as an arbitrator for the EU-US Privacy Shield framework, unanimously confirmed by the US Senate to the Privacy and Civil Liberties Oversight Board, previously chief of the FCC's Enforcement Bureau during the Obama administration, former senior advisor to Kamala Harris, and a special assistant attorney general of California. This list could go on for a while, but I'm going to cut it short here. Travis joining us from LA today. Welcome, Travis.
Thank you very much, Bruce. Great to see you this morning.
Great to see you. Ashden Fein is a partner at Covington. He advises clients on cybersecurity and also many national security matters involving personal data, threats targeting intellectual property across industries, state-sponsored theft of sensitive U.S. government information, and destructive attacks. He previously served on active duty in the U.S. Army as a military intelligence officer and a prosecutor, where, among other things, he was a lead trial lawyer in the prosecution of Private Chelsea Bradley Manning for the unlawful disclosure of classified information to WikiLeaks. Joining us from Arlington, Virginia today. Welcome, Ashden.
Hey, thanks a lot, Bruce. Thanks for having me.
Robert Hudock is a partner in the data privacy and security practice group at King & Spalding. He's represented companies on a range of cybersecurity and data security incidents, including dozens of security breach matters involving tens of millions of affected consumers. He's a certified information system security professional and can apparently more than hold his own in the hacker community. He's a certified ethical hacker and two-time winner of DEF CON's Capture the Flag competition for pro hackers. Very cool. Welcome, Robert.
Thanks. Glad to be here.
He's joining us today from Madison, Virginia. And finally, Kelly Langmesser is a principal at Sard Verbinnen and Company. Kelly advises a variety of clients on issues that are vital in the ransomware area: reputation management, crisis communications and issues management, and cybersecurity preparedness and incident response. She previously served for over 7 years as a spokeswoman for the FBI, where she handled communication strategy and media matters for major cyber, criminal, and terrorism investigations in New York City. Joining us from Midtown, New York. Welcome, Kelly. You're on mute, Kelly, by the way.
Thank you. Pleased to be here today.
Great to see you. Travis, let me turn it back over to you.
Thanks a lot, Bruce. Good morning, good afternoon, good evening to all near and far. I'm Travis LeBlanc from Cooley. I'm your moderator today for this panel on Ransomware 2.0. For those of us who work in the ransom space regularly, it comes as no surprise that exfiltration attacks are growing at a rapid clip. I want to go back in time just a little while ago to shortly after the pandemic overtook all our lives. A June 2020 study estimated that 1 in 10 ransomware attacks involved a threat to expose the victim's sensitive data. Just about a year later, a September 2021 report described exfiltration as nearly 80% of all ransomware attacks. For those of us who frequently get brought in on active ransomware attacks, that means the decisions around how to respond have evolved at an equally rapid pace. Ransomware actors are coming up with creative and unusual ways to shame companies into paying up, from publishing lists of affected companies online to emailing stock exchanges in an effort to harm a company's market value, or contacting individual victims to apply external pressure. Naming and shaming is not limited to companies. We should be clear about that. It's also a tactic that has been used against law firms, like in the Revil attack in May of 2020, raising concerns about how we protect our clients' confidentiality and whether we practice what we preach. During this session, we're going to talk with a group of distinguished practitioners with many years of legal, technical, and communications experience with ransomware. And these issues are really day-to-day what we're all dealing with. Before I begin, I want to invite the audience at any time to ask any questions. I'm going to pay attention to the moderator's docket over here and review any questions that may come in, and I'll try and pose those as we proceed through the panel. But to kick us off, and maybe Robert, you can kick us off with just sort of a background on the concept of ransomware 2.0. What is ransomware 2.0, and are the perpetrators of 2.0 attacks the same as traditional ransomware?
Well, over the last couple of years, we've seen an evolution in ransomware. In the old days, it was simply encryption and payment for Bitcoins to get access to your data. More recently, though, we're seeing this industrialization and specialization of the threat actors. So we have highly specialized, skilled people breaking in and identifying the targets, and then different people that sort of carry out the attacks. And then in addition to that, we also see different ways that a ransomware could play out. So ultimately, the bad guys want to get your payment. Okay. And so there's a couple of different ways that they might be able to do that. One of which is encrypt the data, denying you access to your information, sort of an attack on availability. There is the disclosure of the sensitive information to the public internet, sort of an attack on confidentiality. And then even in situations where it's not just that they post it on the dark web, they'll reach out to potentially patients who are the subjects of the compromised records and then have them agitate in order to try to get you to secure payment so that their information isn't disclosed. And then even more recently, the threat actors will try to use social media and even regulators to say, oh, pay us the money, or we're going to, advertise this to the regulators and say that your cybersecurity is quite poor. And so it's, we can't think of ransomware as this idea where the data is encrypted and, whether we can recover our information or not. It's, can we bear the consequences of these other types of tactics, like the attack on confidentiality and the reputational attacks?
Excellent. I mean, that is a very helpful background. When we often see these, Robert, we actually don't even necessarily see these same tactics with just ransomware. Sometimes we just see it with ransoms, all these same exact tactics that you're describing. Someone finds out that you had a vulnerability. They didn't steal any of the data, didn't exfiltrate it, but nonetheless, they take advantage of that to extort some type of payment out of a company. It's definitely evolving, and I loved your term industrialization is what we're seeing here, and sophistication. And I'm just wondering, are the people that you see behind this, the perpetrators, are they the same people that we were dealing with 3 years ago? They've just now developed a PR arm, or are they a different breed of criminal?
Well, I think it's a different breed of criminal, because we have some nation states that don't prosecute their own people for attacking other countries. And so people that maybe don't have a lot of economic opportunity but have the skill set to carry out these types of attacks are incentivized because of the ransoms to go into the business. $1 million goes a long way in Siberia. And so it's in fact, I remember looking at this blog article where a number of these, some small little town in Siberia, and they're all driving around in super expensive foreign race cars from their profits. So it's in some parts of the world, this is a growth business, and as long as we keep paying the ransoms, it'll attract better and better talent to it.
Yep. Excellent point. And I do wonder how far $1 million can go in Madison, Virginia, where Robert is. Get nice sports cars. So Ashden, does ransomware 2.0 present different challenges to managing notification or other legal obligations?
Yeah, thanks, Travis. As with all incidents, organizations should be assessing their notification and other legal obligations throughout the response, from the initial detection through the close of the incident. However, for data theft and extortion events like this ransomware 2.0 we're discussing, the types of obligations that may be triggered do seem to be fundamentally different than the classic ransomware. As Robert just explained, ransomware 1.0 primarily focused on encryption events that rendered systems and data inaccessible. These are attacks on availability, as Robert explained. So except for requirements that may exist or did exist in certain highly regulated industries or based in contract that relate to mere access to systems or a service level agreement for uptime, the encryption of systems and data or the presence of malware or threat actors within a network alone, without any evidence of access or exfiltration of data, does not typically trigger notification requirements. Indeed, most notifications occurred under ransomware 1.0 for operational reasons. The systems or data were unavailable, core services could not be performed, thus notifications occurred. Or there was a publicly observable event, and for reputational reasons or public relations reasons, there would be notifications. However, for ransomware 2.0, we typically have evidence of data being accessed or stolen based on either forensics or, more commonly, information provided by the threat actors, like, I have this data, here's my proof of life, and I want you to pay me. This makes the response more challenging because organizations now have knowledge or at least a reasonable belief that at least some data had been stolen, and they need to act on that knowledge. So if you know or have that reasonable belief that they stole regulated data, for instance, such as personal data, trade secrets, third-party confidential information, or any other sensitive non-public information, the ransomware 2.0 event is more akin to traditional intrusions and data thefts than sort of the legacy ransomware. So, as we'll discuss, I think, later during this panel, if there's a threat to post the data or dump it online, this certainly can change the equation when determining whether or not to engage and pay the threat actor. So all of this sort of combines into the decision-making that has to happen on whether or not you need to pay because certain types of data had been stolen.
Thank you, Ashden. Very, very helpful primer on how ransomware 2.0 changes the landscape when it comes to thinking about notifications and other obligations. I wonder, just to clarify, would you say it's the same under GDPR? Are you speaking worldwide or really just in the US?
Yeah, and it depends, right? But certainly availability incidents alone typically do not trigger obligations. Certainly under GDPR and some other jurisdictions, if certain data is unavailable and impedes the rights and freedoms of individuals, that could trigger certain obligations. But as a general matter, we're really looking at the compromise of data that triggers the broadest obligations. And that's what we're seeing with ransomware 2.0. So where clients and organizations could feel comfortable that if the incident was completely contained within their network and they're only facing an encryption event and they had the appropriate disaster recovery, business continuity plans in place so their data might have remained available in another form, then they sort of could push past the notification obligations. Now, there's a lot of factors that could come into play in any of these analyses. But now, once we know that the data has left the environment, or we have at least positive confirmation that the data was accessed from within the environment, like I mentioned before, proof of life, file structures that are enumerated and presented to victims, that I think just changes that equation and makes clients and organizations think differently about their notification and other legal obligations.
Excellent, thank you. We have a question from the audience that has to do with payment of a ransom. So I'm going to just read that to the panel and see if any of you would like to tackle this one. One of our audience members comments, a vendor who paid ransom in 2020 said they trusted the cyber criminal to destroy the exfiltrated data because the cyber criminal's ability to extort future ransoms would be diminished if they didn't keep their word. This seems counterintuitive. When the perpetrator's identity is unknown, the concept of reputation seems nebulous. Is this rationale accepted in the industry as sound? What is the panel's opinion of this line of reasoning?
Well, since you're asking about threat actor mental state, I don't know, Robert, if you want to go first. I'm not suggesting you're a threat actor. But...
All right. So I really don't like paying ransoms, and ultimately you have to realize you're dealing with a criminal, okay? And if it's in their best interest, typically their short-term best interest, in order to disclose this information, even after sort of telling you that they wouldn't, and you paid the ransom. We've seen situations where you pay the ransom, and then they come back and then they ask for another ransom.
Yeah, and maybe let me just briefly and maybe ask Kelly to jump in too. This is actually where we, one of the many areas we work closely with public relations experts like Kelly, because sure, a criminal can commit to deleting the data. They could present a video showing them deleting the data. They could present other artifacts showing it. But at the end of the day, we have to assume and should assume that they've kept copies, or maybe they're not even knowing there are copies out there that were made of the data. Which is why, regardless if you pay or not pay, and whether a criminal commits to pay deleting or not, you should probably have a good plan in place in order to respond if that ends up not being true. And as I started with, and maybe hand it off to Kelly, that's where working with Kelly could come in quite handy in preparing for that contingency.
I mean, one thing to keep in mind is that, whether to pay or not pay, we can't advise on that. But, when it comes to thinking through how you speak to your constituencies about this, are you doing everything to keep their data safe? Now, that doesn't keep us out of the wheelhouse of Ashden, whether you're clear out of notification requirements, but it's something you could turn around and say to your stakeholders, we did everything we could to keep your data off the dark web. Again, not endorsing paying or not paying. But again, back to Ashton's point, though, that's where a good scenario plan comes in. Okay, we think we're in the clear. The data's been deleted. Option A is we reactively respond to things as they come. Option B, the data comes up for sale later. How do you explain to your stakeholders on having some kind of core messaging and things to set forth, like how you're going to communicate that this happened? We did everything we thought to keep the data safe, and then eventually the threat actor broke their word.
And Travis, maybe just to circle back to, I think, the second part of the question is industry practice. I'll certainly say from my experience, I don't know what the overall industry practice is that many organizations do at least rely on the fact that they have paid for a certain service from the threat actor, which might include destruction of data, and that the threat actor has attested to that, not under some legally enforceable means. And those organizations have relied on it. Now, that doesn't mean they've avoided legal obligations to notify or take other actions, but that the fact that threat actors make that commitment and victim organizations rely on it, I have seen that probably more often than not.
Excellent. Thank you. Thank you. Let's move on to another topic, one more on the communication side. Normally, when we're discussing a cyber event, it becomes public when a company reports it or the company services go down. That's how the world tends to find out about them. With Ransomware 2.0, the attackers are threatening or actually exposing not only to expose the attack, but also what they, disclosing what they obtained during the attacks. Kelly, what are the considerations for how to communicate internally and externally about Ransomware 2.0 attacks and responses?
This was brought up earlier, and it's because these actors have their own PR channels. Like Robert talked about, they're putting things out on social media. They're posting things on the dark web. There's cybersecurity researchers looking on those spaces. Media are trolling those spaces and reporting on it. There's all these different venues where it could come out not from the company. The two main key considerations are, first, what are your, going back to Ashden, what are your legal obligations? We've talked about, if data was accessed, what reporting mechanisms are you going to need to do? Are you going to need to send notification letters, and attorney generals post those now? Are you going to need to contact a great number of clients that your contractual IP was taken and you need to notify them? HHS OCR site is posting things. There's different venues where it's going to become public to the surface. The second consideration is, what are your business goals? In an incident, you're trying to keep your business going, but you also have to maintain trust with customers. You have a nervous and frantic and distracted workforce. You have to keep those in mind when you're responding to an incident. Is how can you calm their fears, show credibility that you're going to do the right thing? It's not sufficient in this time to just keep your eyes closed and think that it's going to go away and you can get your operations back up with a switch of a light and it's going to blow over and no one's going to know about it. In this day and age, that's probably most likely not going to happen. And so you have to plan for if and when it does become public. And you don't want to be on your back foot trying to have a regulator or an attacker social media account speak for your company. You start out on your back foot and you're not in the best position, to keep your business narrative going, that you have the trust and you've done the right thing.
Yeah, the challenges are real. We see them quite often, Kelly, and we see every single flavor of what happens when you don't get the communications right, and how it's got a long tail. And the tail is much longer than just getting your systems back up and operational. It can be around for years in several different forms.
It can, and then there's also a new thing we're seeing in the last year with the Aceli and ATF attack. Over 100 organizations were included in that, some universities. The attackers were sending notes, they had the email addresses to in the people they attacked, and they're sending, in a university, we saw they're sending notes to the students saying, tell your university to pay us or we're going to put your data on the dark web. So there's just more aggressive tactics. So to get in front of that and show all your stakeholders that you care and you're doing the right thing.
Thank you. Let's suppose for a moment that there is an ongoing ransomware 2.0 attack. Robert, I see you came off mute, so I'm going to direct this one to you, Robert. You look like you're interested in this one. Ongoing attack. Unlike Ashden and I, which we're just mere lawyers, Robert is both lawyer and hacker. So, Robert, wearing your technical hat as well as your legal hat, how does a company determine that exfiltration actually occurred? And what can you do to understand the nature and extent of exfiltrated data?
Yeah, so this is probably where I do some of my best work, and as you figured out, and that is what really happened here, and because it dramatically affects your legal obligations. If we can definitively show that something didn't happen or something did happen, then it fills in some, we don't have to sort of assume the worst case scenario anymore. So right off the bat, exfiltrating data is time consuming. And so the time that an adversary has had access to your systems is key to understanding how much data could have left the organization. Okay. And so, the longer the threat actor is in, the more that, we have to worry about data leaving the organization. Okay. If it's a very short period of time, you will see data leaving. All right. Organizations monitor network traffic, net flow, firewall logs, file system metadata are all some resources that you can rely on in order to say what sort of left and what sort of didn't leave. And remember, the bad guys are going to lie to you. We've had incidents where they say that they have all this stuff, but the reality is they don't. Okay, because the time that was necessary in order to download it far exceeded the time that they were in the systems, and we were ultimately able to show that. The other thing to keep in mind is the adversary may not know what information is most valuable, because there's a lot of junk stored inside corporations. And so we've had incidents where the bad guys are in there a week and all they do is manage to download lots and lots of security video footage. Okay. And so, but they didn't really understand what was the really valuable information. Okay. And so understanding sort of the nature of what information could have been taken, how long that could have, occurred for, and then comparing that to baselines. Now, one other thing that is really in the last year or so that I think is really key. Most of these bad guys, they're not downloading this stuff to their home computer. They're downloading it to Amazon or Azure. Like these are resources online that they've set up. And so if we can move fast enough, we can get control of those virtual storage, let's say S3 at AWS with a court order. And those repositories will have extensive logs, which you can, effectively rely upon to say what happened and what didn't happen. Okay. And so if the bad guy transferred it to a bucket at S3 and didn't do anything else with it, and we can show that with logs from both systems, then that can be used as a way to reduce the impact, because these guys are not downloading it just to their home computer. They're downloading it typically to some sort of cloud resource that if you take quick legal action, you can get control of.
Yeah. So Robert, with that one, so the challenge that we often find ourselves in, but you may have the answer to it, is ransomware 2.0 attack. Our system, the perpetrator exfiltrates some amount of data, then locks everything up. So here we are now trying to investigate it while it's all locked up to figure out what they took or didn't take. How does that complicate? Because a lot of, it's different than just taking it and trying to figure out whether it's been exfiltrated. It is, your systems are locked up at the time that we need to figure it out.
So, and this is an excellent question. Okay. Fortunately, the ransomware typically won't target certain files, because if they were to target certain files, let's say the operating system files in some logs and things like that, Windows registry, it would actually catastrophically damage those systems. There would be no way to actually recover that information. Okay. And so there is typically some way to be able to get a view on what the adversary did. Now, it may be complicated, okay, but the adversary can't effectively cover all their tracks, because if they did, it would destroy the ability of that system ever to recover. And so you as a victim, if you can't boot that system in order to apply the decryptor, then they've effectively lost their opportunity to get their payday. Okay. Also, keep in mind, modern computers store huge amounts of data. Okay. And a lot of times the stuff will be deleted. Okay. And it won't be wiped. That means you can recover details from unallocated space on these machines. You can recover detail from memory captures and things like that. And so, all of this, though, relies on you being able to get in there and collect this information as quickly as possible. Okay. So excellent point. But, it's not as helpless as you might think initially.
Excellent. Thank you. Ashden, does exfiltration and or the threat of exposure change the calculus on whether to pay the ransom or contact law enforcement?
So I guess simply put, yes, I think it does. For ransomware 1.0 incidents, the threat actor activity, as I mentioned earlier, was typically contained within the victim organization system. So the encryption event occurs, and the victim is faced with the decision to pay, typically for the decryptor, as Robert just spoke about, or not. So the decision is, do we need to pay to get our decryptor in order to get our systems and data available? So if a victim has a strong business continuity and disaster recovery process, if they're highly resilient, and they don't require access, for instance, to the original systems or data, then the incident may be simply an expensive annoyance at worst. But if the victim cannot recover its systems or data in a timely and accurate manner, then the victim would need to decide whether taking the risk to pay would benefit them. So, but with data exfiltration and the threat of exposure, the calculus can change. So rather than focusing on our own resilience and ability to recover in a timely and accurate manner, which is focused on mitigating the risks related to the availability of the data in the systems, organizations find themselves focused on, or also focused on, if you still have that encryption event you have to deal with, mitigating the risks related to the theft itself and the possible publication, disclosure, release of the data. So the questions I typically ask clients are, one, do you need the data back because you don't have it anymore? Is this the type of data that there's no accurate copies of, and you may need to engage a threat actor in order to obtain a copy of it in return? What are the risks to individuals, the business, and other stakeholders if the data is posted online or proliferates around the dark web? And it could proliferate, of course, in perpetuity. Will engaging the threat actor mitigate any harm to any stakeholders? So, for instance, we talk about the risk. If the risk of having medical records, as I think Robert mentioned earlier, posted online, will engaging the threat actor and having that information brought down, even if there's a chance they won't fulfill their obligation, will that somehow mitigate harm to a stakeholder, and should you pursue it? So I think, there are other questions, of course, to consider, but those three, I think, help to sort of define the equation for that calculus on whether to pay a ransom, engage with the threat actor and pay. But now, regarding law enforcement, it's certainly a good practice to engage law enforcement for many, if not most, cyber incidents, and especially those involving ransomware. As the audience has likely heard and will hear throughout today's sessions, it's highly advisable and practically required to engage law enforcement if a victim intends to engage with and pay a threat actor. So given that, I'm not sure that the mere fact of having data stolen and extorted for that for some payment changes the calculus alone, but it certainly would counsel in favor of engaging law enforcement if the fact the data was stolen is pushing a victim who may not otherwise have been inclined to pay a threat actor, to engage a threat actor and ultimately pay. And if that's the case, then I do think it would change the calculus on when to and if you should engage law enforcement.
Yeah. Ashden, we have a question from the audience that's kind of a twist on this one, which is, what about if there's a second payment? That is, what would your thoughts be on an attacker who's been paid and then comes back for more money? What calculus, or what do you consider in making the second payment? Is it the same questions, or would you consider other factors?
Yeah, that's a good question. And I think actually combining it with the first question we received from the audience, I think first and foremost, before making that decision, you really have to try to develop a good understanding of your threat actor. And that could come from many different sources, but I will say, as a very positive note for the FBI and US law enforcement, is that, over the last 18 to 24 months, there's been a lot more information sharing, especially with ransomware threat actors out there. So before you ever engage with a threat actor, going to your various sources of intelligence and information can help inform whether or not a certain criminal group is a, quote, trustworthy criminal group, whether or not a criminal group is known to re-extort off the same event or future events. And that type of information could be incredibly valuable. But regardless, a threat actor is a threat actor, and they could still operate outside of their standard tactics, techniques, and procedures, as one of our clients has recently, unfortunately, experienced. So with that being said, to get back to the specific question, I do think the calculus is going to change if the same threat actor is coming back at the organization regarding the same event. So you pay to have the system decrypted, and then you're paying, with the threat to have the data released or returned or not posted. That being said, a lot of this happens very quickly. And I think although that risk exists, in my experience, and I'm sure everyone has different experiences and should share here, I would say that slowing down the first payment, hopefully to avoid a second payment, could be a tactic that could be deployed, because typically a threat actor, at least in my experience, will escalate by then moving into data theft extortion, because they've already likely stolen the data by the time your systems are encrypted. And so, holding off on the decryptor engagement to really understand whether or not you can forensically tell, or you need to know from the threat actor if the data was stolen. Hopefully you can combine the two into one negotiation and one transaction.
If I could add one thing on
Yeah,
contacting law enforcement, is that, again, I defer to Ashden and Robert on their counsel to clients, but that's one thing we can use to kind of, you're being extorted at the end of the day, and you're a victim of a crime. And that's one thing we can use in the communications to say that you're, again, doing everything you can to kind of respond to the incident, and you're a victim. We were attacked. We have reported it to law enforcement. It's no different than a bank being robbed at the corner of 53rd and 3rd. You explain to your stakeholders you're doing everything you can in the incident to respond.
Yep. Very, very good points. We got more questions. I'm going to go back to Robert for a minute on some questions about the comments that you last made just a few moments ago about AWS or Azure. So you've got a few questions. One is, what steps do you recommend for obtaining a court order to ensure bad actors does not remove data from AWS or Azure? Another one related to this is to kind of explaining the legal theory behind this was a question that we got. And then the last one is, can there, I'll just leave you with those, I'll just leave you with those two.
Okay, all right. So I'll sort of combine them together in order to sort of address this. The general process that we would go through is get an emergency TRO, a temporary restraining order, which would actually give us control or force AWS at the minimum to take control and not allow anyone to access that environment, to shut it down. And sort of as a holding pattern, your most immediate ask would be, how about we deny everybody access to this environment, okay? And then eventually we go through and we follow up and say, we want some specific information from here. And we work either through the judge or the cloud vendor. And by, it's actually a lot easier than you might think in order to get one of these TROs, in order to get access to the environment. I'm sure everyone on this call has contacts at AWS, Azure, and all the big players out here. And you file the request for the restraining order in your jurisdiction, and it's typically really fast. You can do this in 24 to 72 hours, depending on just how everything sort of flows together. Initial ask is shut everything down, and then let's talk about the information that we need. And then AWS is very amenable, so is Microsoft, to sharing this type of information. And fortunately, they keep very good logs. They need very good logs for billing purposes, and we take advantage of that. So the sort of the cause of action here, or the premise would be they stole our data, okay? And so we're basically trying to secure our business IP or this confidential information that we were custodian of. And there's various claims that we can make under that in order to state a claim under state law or federal law in order to get access.
A related question to that, Robert, was how do you know that they've actually put the data, stored the data in AWS or Azure?
That comes from the logs. Or so, let's play through I'm a bad guy. All right, I want to exfiltrate this information. It's a Microsoft system. Like, they're typically going to do something like PowerShell. And this cloud vendors will have PowerShell libraries. And in the commands that you use in order to exfiltrate the information, it includes all the details of where it's going. And so that's how you know. And so if you can shut the system, get good forensic images very quickly, or alternatively, sometimes the threat actors actually don't cover that up. They want you to see that the information left. And so those PowerShell scripts aren't encrypted, and those configuration details can be recovered directly from the file system, because the configuration files are still there. Okay. And so it's something that you should be able to recover rather easily through forensic examination.
Got it. Kelly, let's go back to you for a moment. There's, a question for you about, well, first, one person commented on your 53rd and 3rd reference to Ramones, I think it is, but we're going to leave that one aside. Another person noted that you mentioned that taking the position of being a victim of an attack with law enforcement. Someone was wondering whether that would open the company up to a critique of having weak preventative measures, and whether that risk of being a victim makes you look like you were irresponsible with your own security.
I would say no. I mean, look at, I hate, like the last year and a half, how many victims have there been? I mean, I hate to say there's safety in the herd, but I mean, every company from, Fortune 500 to smaller businesses are getting attacked. Someone is sitting in another part of the world 24 hours a day trying to get into our systems. So, eventually if there were weaknesses, that would come out a longer time. But at the, in the initial stages of attack and, disclosure, you're sharing that, you were attacked and, your systems, someone came in and like broke down the door and took things. I think it's just no different than, I stand by the statement that showing that, you're doing everything you can.
Yeah. And speaking of doing everything you can, what about the preparation side? Kelly, we've been talking a lot about the response side, but does Ransomware 2.0 present additional considerations that companies should take into account in preparing to respond to an attack?
It does, because these situations, Ashden talked about this earlier, I think Robert did, Ransomware 1.0 was that the systems are down and there's a noticeable, operation shutdown. And you usually have to publicly share, our systems are down, something like we're responding to it, we're getting them back up. When you come to 2.0, you could have that for a limited amount of time, and then eventually the investigation continues, and then you have, you find out there's, obligations to either notify through contracts or, regulatory obligations that you're going to have to make a public disclosure about it. And, it kind of thinking the fulsome picture is that you can't just hide this, that it may be months later and how you're going to communicate about it. When preparing for that, it gives you a chance, not in the fog of an incident where you're sleep deprived and anything else deprived of trying to, running on 24/7, is that to think strategically about how you can have a thoughtful, disciplined, strategic approach to responding to it. And, you don't want to inflict damage on your reputation, your legal obligations, your investigation. So taking the time to sit back and, think about 3 important things. First is who your key stakeholders are. Who are your VIP clients or customers that you really need to speak to about it? What contractual obligations? Do you have a short list that you're going to need to speak to, clients that about you had an incident? Second, how do you communicate with them? What if those normal channels, do you use like an email service? Do you use phone? Like if you can't get access to those, how do you communicate to those key stakeholders that you identified first? And then third is what you're going to say. And what does that say about your company? Are you going to demonstrate transparency, integrity, and trustworthiness? Those 3 things you can factor into a strategic plan and how when you're preparing for it. Another thing about is setting up guiding principles and like going back to that, are you going to be transparent, or are you going to try to not, try to withhold information from your, for business reasons? We develop clients for, hundreds of these plans, and they're all bespoke when you take those 3 factors of, who you want to communicate with and how you want to communicate with them. You can separate each audience. You have to think about your clients. If you have certain subscribers that are considered more like paid, or they're offering a free, how do you communicate with each of those groups? And this time gives you a chance to really think through what you're going to say to each of those groups. Another thing to think about too is that if you're in a ransomware, if you're going to communicate about the payment, again, not saying pay or no pay, but would you share that? Again, we talked about this earlier. Are you going to show that you did everything to keep their data safe? Are you going to show that you're paying a criminal organization? These are all things that you can think through, not in that fog, and decide as an organization how you want to respond.
Thank you. Thank you. The preparation side is one part on the sort of the comm side, but it's also another part on the financial side. And we haven't talked about insurance coverage. Ashden, does Ransomware 2.0 present different considerations with regard to insurance coverage? you're on mute.
Despite 2 years in the pandemic, still can't come off the mute. So Travis, thanks. I would say, first, as a disclaimer, any discussion about insurance coverage, a victim should review its policies, consult with its broker and coverage counsel, which I am not. However, for today's purposes, I'll simply say that the data theft with or without the naming and shaming may be covered under various insurance lines. The payment of an extortion demand may also be covered with or without a traditional, malware-focused ransomware event. The market is certainly changing quickly, so it's really important to know what your coverage is and what the requirements in order to make a claim are. If a victim organization has coverage that may apply, it is critically important to assess the coverage very early on and make a decision whether to notify insurers about the event to maximize coverage. This is true, of course, for many types of cyber incidents, whether they're data breaches, they're OT, critical infrastructure incidents, or trade secret thefts. At the end of the day, you always have to make these decisions. But with ransomware 2.0, what we've seen is that this decision is just critically important to be made early on, because the decision to engage a threat actor and to pay to have data not disclosed or posted may need to be made within 24 to 72 hours of detection. And so during those first few hours, those first 24 to 72 hours, there are many different actions that have to take place. There's many different decisions that need to be made to get to that ultimate decision of whether to pay or not to pay. And I wouldn't want any victim who may have insurance coverage to lose out on that coverage because they missed a notification or a consultation requirement with their insurers. So it's just something that needs to remain on the checklist. It needs to be reviewed throughout the window of making the decision whether to pay, and circle back right before the payment is made, if a decision is made to do that, just to ensure all of the I's are dotted and T's are crossed for insurance.
Yeah, thank you. We have an interesting question from the audience that is really about the future of ransomware. And the question is, do we have any thoughts on whether there will be a ransomware 2.5 or a 3.0? And what does the panel think that could look like? Another way of saying is, where do we expect ransomware to go in its evolution?
So I've got I don't want to give the bad guys any ideas here, but data integrity, I think, is one area where the bad guy breaks in and they make slight modifications to the underlying data such that it changes maybe key aspects of the medical record or something like that, where you don't know what the hackers have touched and what they haven't touched. And in order for you to be able to restore your systems or to restore the integrity of your data, you pay them in order to get that information. And so some sort of nuanced attack against integrity where there's subtle corruption opposed to massive encryption of the data in order to get some sort of payment.
I think I'll jump in here. I think absolutely. I can't give a prediction of where it's going to go, but we've already seen it used to be you just operate closed on, as we all know, you just shut down the systems. And then we saw where they threatened the organization, well, we're going to share your data. And I mean, I spoke about this earlier, where they're literally contacting the data you have, the individuals you have in your systems, the students, your customers, saying, tell your organization to pay us or we're going to share your data. It's such a sophisticated step that we haven't seen. I think it'll continue to evolve. I mean, just look at where it's been. Like any criminal organization, it evolves, it separates, and it continues to go on. And it's a sad thing that we're living in this and students get emails that their data could be on the dark web. I'll say that.
We have about a minute left. Ashden, do you have any commentary on what you think might be the future of ransomware?
I don't. I just hope that organizations can. I have theories, but no, I just hope that organizations can remain resilient and can have the appropriate resources in order to proactively protect themselves and remediate vulnerabilities that could be exploited in order to have the ransomware 3.0 or the ransomware 4.0 in the future.
Well, excellent. I see Bruce has joined us. This was a great panel. I hope everyone in the audience enjoyed it. And Bruce, I'm going to turn this back over to you.
Thanks, Travis. Terrific job. As always, you were born to moderate, that's for sure. Thank you to everybody, Robert, Kelly, Ashden, terrific panel. And we really appreciate everybody's time and thoughts. So the next panel, we actually have a 10-minute break. So we'll be back here at 11:35. The next panel is ransomware attacks before and after, preparation, governance, training, and remediation. We'll see you at 11:35. Thanks.
Thank you, everyone.
Thank you.